Hello, my name is Dorit Reiss. I'm a professor of law in the University of California, Hastings College of the Law, and a member of the Vaccine Work Group on Ethics and Policy. My goal in this video is to explain the law as it relates to vaccine mandate in the context of COVID-19 vaccines. I'm going to skip the factual background to COVID-19 vaccine and focus on who can mandate what and what are the limits on that. This is a short version. It doesn't go into as much detail as a thorough legal analysis would. It's to introduce the topic for lay people. I also have a conflict of interest, which is that my family has general stock in GSK, a vaccine manufacturer, who I think has an early candidate for COVID-19 vaccine. Not sure if it's related to anything I say, but for full disclosure. So my presentation will cover 4 parts. I'll talk about whether the federal government can mandate COVID-19 vaccines and under what circumstances. I'll talk about whether the state can mandate them. I'll talk about private employers, and I'll say something about private businesses requiring vaccines for their customers. Let's start with the federal government. One statement though. Before we go into mandates, remember that my focus here is on what the law allows you to do. I'm not recommending any specific policy choice. I want to talk about what you can. As a general thing, just because you can doesn't necessarily mean you should, and keep that in mind. Let's talk about federal mandates now. So the federal government is a government of limited powers. That means that the federal government can only act within its permitted sphere. The federal government has been acting in public health for decades, mostly using one of 2 of its powers, either the Commerce Clause or the Spending Clause. Can the federal government use either to impose a COVID-19 vaccine? To some degree. First of all, aside from those 2 powers, the federal government does have the authority to regulate who comes into the United States, and therefore it can, for example, require COVID-19 vaccines for entry or for foreign travel. It could condition passports on a COVID-19 vaccine. It can also use its commerce powers to require vaccines for interstate travel, whether through planes, through trains, and so forth. It could also, to some degree, encourage states to impose mandates by conditioning certain funding on mandates, but there are limits to that, limits from the coercion doctrine. In the past, the federal government have used this authority under Section 361 of the Public Health Service Act, which gives the Surgeon General the power to regulate to prevent infectious disease, to impose different regulations related to infectious disease. One of them, for example, is the CDC's moratorium on eviction during COVID-19. Maybe you can think that Section 361 allows the federal government to impose a vaccine mandate, but that's tricky. Eviction moratorium addresses the housing market, which is much more closely related to interstate commerce than vaccines mandate generally. So chances are the federal government does not have the authority to impose a universal vaccine mandate, but may have the authority to impose a narrow mandate, for example, on international travel. I will add, even though that's not part of US law, that we may see vaccine travel mandates from other countries. Right now, countries in Africa mandate vaccines for yellow fevers in some circumstances, and they may require that travelers from the United States show proof of COVID-19 vaccination. Let's talk about states. States have the plenary power to regulate in the public health. They have the main authority. And the classic case saying that states can impose on individual rights in the context of public health, Jacobson versus Massachusetts, is about vaccine mandate. In 1905, the Supreme Court upheld the authority of a state to require vaccine in some circumstances. So you can say maybe there's authority, but we want to cabin that with a few caveats. First of all, it's been a long time since Jacobson, and we have a jurisprudence that promotes individual rights since. That said, under COVID-19, many courts have deferred to strong public health measures using Jacobson without regard to the jurisprudence. So there's some legal uncertainty here. Further, the circumstances in Jacobson were not of a universal state-level mandate on all adults. It was a local mandate related to an outbreak of smallpox in a specific locality. So there's a question whether that is good authority for a universal mandate on a whole state. Jacobson used a fine, but I would be careful giving too much weight to that, because Jacobson itself referred to jurisprudence about school mandates. So it suggests that it's not about the sanctions so much as about the principles. Jacobson also imposed limits, including that the measure has to be for public health, reasonable, proportional, avoid harm, and imposed fairly. You can't, for example, discriminate on the basis of race. In the past century, we have never had the state impose a universal adult vaccine mandate. We have, however, seen narrower mandates. Some states require vaccines from healthcare workers, and in 2019, during the measles outbreak, New York City imposed a limited mandate on several neighborhoods that saw high rates of measles. They imposed a mandate requiring anyone who is not vaccinated against MMR and doesn't have a medical exemption to pay a fine of $1,000. That was upheld in a lower court, so there's that in context. Another thing to remember is that there may be questions related to religious freedom that apply here. Before I address religious freedom, I want to say something about the specific context of COVID-19 vaccines that are only authorized under an emergency use authorization. These vaccines are not yet approved. And there's a question, can you mandate vaccines under an EUA? And the answer is that it is unclear. There's likely to be litigation on that, and there's no previous jurisprudence. My assessment is that it's 50-50% likely to stay in court. The language of the Emergency Use Authorization Act is unclear. It, on one hand, mentions that people can refuse a vaccine, but it also mentions that there may be consequences, which may include a fine, may include being fired. The language of the EUAs himself, for Pfizer at least, did not clarify that. It also addressed the ability to refuse, but it says that in addressing consequences, that there will not be an impact on your medical care if you refuse the vaccine. It didn't say anything beyond that. So there's uncertainty there. The other question for state, again, is a question of, do they have to give an exemption from any mandate they impose for religious reasons under the religious freedom jurisprudence? And here we have the development. Since 1991, the standard in the United States under Smith Employment Division versus Smith is that for a general law, you do not have to give a religious exemption. There's a general exception to that, which is if you are motivated by hostility to religion and you're trying to hide it by passing a general law, your law will be subject to strict scrutiny. There's also some judges that think that any exception triggers strict scrutiny, but that has not been a majority or universal approach. But in 2020, in a case addressing limits on church, the Supreme Court in Roman Catholic Diocese versus Cuomo said that limits targeting churches specifically had to meet strict scrutiny. Now, that doesn't change Smith, but because the Supreme Court went out of its way to decide that case, the limitations have already expired and the court still spoke to it, it may be an indication that the court will move to stronger protection of religious freedom and the law might change going forward. So we don't know whether we'll see tightening of the religious freedom jurisprudence. I will add that about 20 states have Religious Freedom Restoration Act that require that any law that burdens religion has to meet the standard of strict scrutiny, which means it has to be for a compelling state interest and the least restrictive mean, unless it's giving a religious exemption. So if you have one of those Religious Freedom Restoration Act, if it's in the Constitution, every statute has to meet it. If it's in a statute may have to address it expressly. And if it applies, you have to show that this was done for a compelling state interest, and preventing COVID-19 is almost certainly a compelling state interest, but you also have to show that this is the least restrictive mean, and that's a very high bar. Let's talk about workplace for a few minutes, because a lot of mandates may come not from the state or the federal government, but from private employers seeking to make the workplace safer. States might also incentivize employers to do this by offering rewards to employers that have a high vaccination rates or through licensing rules, etc. Can employers mandate a vaccine in the workplace? So the starting point is to remind you that we already have vaccine mandate in certain workplaces. Some healthcare providers require, for example, influenza vaccine. The University of California has recently required influenza vaccine, at least temporarily. Some restaurants require hepatitis A vaccine. So vaccine mandates in the workplace are not new. And the starting point for that is that private employers can impose health and safety rule, and a vaccine mandate is a health and safety rule. So the starting point is yes, they can. There are limits to that. The first limit in this context is, again, the question of can you impose a workplace mandate when the vaccine is only licensed under an emergency use authorization? Remember that generally employers do have this freedom. The EUA Act, the statute creating the emergency use authorization, doesn't speak about employers. It addresses providers and vaccine recipients. And there's at least an argument that using such vague language to impose a rule or a standard that prevents all private employers in the United States from imposing rules they normally would be able to impose is tricky. On the other hand, an EUA is an experimental vaccine and is authorized for limited purposes. So again, we have legal uncertainty. It's not clear that employers can require a vaccine from their employees under an EUA. I will mention as the last point on the EUA that tests for COVID-19 have been authorized under EUA, and employers have been requiring that. That's not quite a vaccine, but we have seen testing mandates in the workplace under an EUA. So if that's a precedent, and there's no legal court precedent on this, if that's a precedent, maybe employers can do this. There's three other limits on the ability of employers to require vaccine in the workplace. First, if the workforce is unionized, there may be limits from collective bargaining. There may be a requirement to negotiate with the union before you can impose a vaccine mandate. This requires looking at two things. First, is there a union? If you're not unionized, this doesn't apply. Second, what does the collective bargaining agreement say? Some collective bargaining agreements will require that negotiation, some will not. I will add that the unions may take different approaches here. Some may be very keen to protect their members' freedom to refuse, and some may be more keen to protect their members from COVID-19 and may be supportive of a mandate. The second limit is from the Americans with Disabilities Act. The Americans with Disabilities Act, in essence, says that if an employee has a disability, you have to accommodate them unless it's a substantial burden. This means that there's three parts to this. Either a disability, and yes, a contraindication to a vaccine is probably a disability for this purpose. Second, what does it mean to accommodate an employee? It doesn't mean giving the employee exactly what they want or letting them attend the workplace in the same conditions as everybody else. It means working towards allowing them to participate in spite of the disability, offering a reasonable alternative. That can be wearing a PPE, working isolated, working remotely if that's an option, and so forth. The third part is what's an undue burden? And in this context, in the Americans with Disabilities Act, it's a pretty high burden. It has to be significantly burdensome for the workplace before you can get out of it. As I'll say in a moment, for religious exemption, it's different. And finally, there is an exception to this requirement of the Americans with Disabilities Act, and that is if you can designate an employee a direct threat. And the Equal Employment Opportunity Commission suggested that COVID-19 may be a direct threat in the context of testing. So if you can point out that the employee is a direct threat to others, you may not have to accommodate. I will say that as COVID-19 declines, maybe one employee that's not vaccinated will not be considered a direct threat. Again, we'll have to see how things work out. The last relevant limit on employers is from the Civil Rights Act of 1964, which prevents discrimination in the workplace on a number of categories. One of them is religious. And what the act means is that if you have an employee with a sincere religious objection to a vaccine, you have to accommodate them unless, again, it's an undue burden. And again, there's three parts to that. The employee has to have a sincere religious belief. And this is an area where there are a lot of pitfalls because there's some things you can't do to assess sincerity. You can't require a letter from the priest. You can't assess if the belief is rational. You can't try and get at whether the employee sincerely believes or does not. Many employers think that if they offer religious exemption, they're home free, but the litigation I've seen in influenza mandate on this is almost all from places that offer the religious exemption, but had challenges to how they applied it. You have to accommodate an employee unless it's an undue burden. An undue burden here is a lower bar. It has to be no more than minimal cost. So if it's more than minimal cost, you probably do not have to accommodate the employee. And again, you have to offer reasonable accommodation. Not necessarily what the employee wants, but measures that can reasonably give them a chance to work in spite of their religious objection. That's the 4 limits on workplace mandates. Be aware that states sometimes have laws that make the protection of disabilities or the protection of religion stronger, but they will still follow much of this same pattern. How about private businesses? Can private businesses mandate vaccines? Can they say, vaccinate or you can't attend my concert, you can't come into my store, you can't come into my restaurant? So the starting point for this is that private businesses have rights, and the rights include being allowed to limit who can come in. Think about the famous sign, no shoes, no shirt, no service, or today, no mask, no service. Similarly, a private business can normally require a vaccine before use of its services. They have freedom to do so. There are some limits, however. First, private businesses are often licensed by the state, and the licensing may include conditions that limit the ability to mandate. Second, some businesses are also subject to the Civil Rights Act of 1964, and everything I said about religious exemption in the workplace will apply to them as well. Those are businesses that are places of public accommodation, which includes hotels, motels, restaurants, movie theaters, stadium, and concert halls. So those may have to accommodate customers with sincere religious objections. And finally, a broader range of businesses subject to the American with Disabilities Act, the ADA, and those businesses will have to comply with the ADA, as I explained, for employers. Those include not just places of public accommodation, as I just talked about, but general retail stores. The state can add to that, can add additional limits, but it may not.